Good afternoon, but also good morning and good evening to everyone. I'm Roberta SOLIS, the Judicial Integrity Team Leader at UNODC's Global Program for the Implementation of the Doha Declaration, which acts as the Secretariat of the Global Judicial Integrity Network, a platform of judges and for judges to provide support in strengthening judicial integrity worldwide. It is our pleasure to welcome you to the first webinar of 2021, number 10 in total in the series of webinars organized by the network on the priority topics identified by its participants and that constitute new challenges for judges and jurisdictions across regions. With this initiative, we aim to continue to broaden the opportunities within the network for networking and knowledge exchange. Before introducing our panel of experts of today, I would like to give the floor to the coordinator of the Global Program for the Implementation of the Doha Declaration, Mr. Marco Teixeira, who would also like to greet the audience of our webinar. Marco, the floor is yours.
Thank you, Roberta, and a big good afternoon from Vienna to all of you. And it's for me a great pleasure to greet you all. And as Roberta mentioned, this is our first webinar from the year 2021. But in fact, our initiative and our series of webinars were launched last year with great success and very positive feedback from all the participants. And I'm glad to see today more than 180 persons connected. And I think this reveals the interest and also the great interest that our webinars are basically gathering from all of you. So thank you for joining us today from different parts of the world, I also can see. Let me start by thank you all of you to being here today and demonstrate your commitment to judicial integrity. From the network, we look forward to continue the work with you during 2021 and offer you and continue to offer you specialized content for judges and by judges on those priorities and emerging topics on related with judicial integrity. And also they are reflected in the importance of the theme of today, how to use social media to bring the public closer to the court. Secondly, from my side, I would like to emphasize how these events are part of our purpose to continue to advance the global judicial integrity network and continue to provide practical examples and lessons learned from experts worldwide to encourage judicial transparency and the use of social media platforms for community outreach in the delivery of justice. We are very happy to discuss today with our excellent panel and experts specific experiences of some jurisdictions in the United States. And this is intended to be a sampling of various good practices that we have been identifying worldwide through Global Judicial Integrity Network channels and colleagues and peers. I want to thank our three speakers very much for taking their time to share your expertise, your knowledge, and also your challenges that you face in your professional and daily lives. Judges and judicial institutions are part of the communities they serve and should not be isolated from them. Educating public about the work of judiciary, opening the judiciary up and make it more understandable and accessible to citizens are for us examples of how judges and the judiciary should undertake and getting closer to the societies they serve. Because it's this mutual accountability and openness that will reinforce the legitimacy of judicial institutions and naturally the public confidence in the justice they are receiving. And obviously the justice will be strengthened. To this end, we have a set our social media platforms can be an ally, especially during COVID-19 pandemic, to promote not only access to justice and judicial information, to create a way to bridge the need to connect with the judiciary. And that brings necessarily the public closer to the judicial systems. And I want to ask Christina, can you share a little bit the slide that we have prepared? And I think this slide is something that I want to highlight before I conclude, which is a quote from our Secretary General. Basically, To this end, and the tweet that the Secretary General of United Nations, Mr. Antonio Guterres, invites all of us to work together. This must be a year of healing from the pandemic and healing our broken societies. And let me say, and I will read basically his quote, we must tackle the fragilities and strengthen our mutual bonds based on our common humanity. Finally, I want to once again thank you all of you for your continuous support, to being with us today, support the work of the Global Judicial Integrity Network, and your presence in this webinar is obviously a factor of motivation to all of us. These webinars and specialized discussions are part of our work, and we will continue to do this path with all of you. I hope this webinar will be useful and interesting for all of you, and I think this topic is increasingly gaining prominence in the interest of promoting judicial transparency and obviously community outreach in many jurisdictions. So a big thank you also to my team, Roberta, to you, to Cristina, to Melissa, to Tatiana, because with you, there's nothing is impossible. 1 year ago, more or less, when we started these webinars, we will not tell that we are close to, well, we are above 200 persons on this webinar. So well done to you, and over to you. Thank you.
Thank you. Thank you very much, Marco, as usual, for your support to the activities of the network. Thank you also for your kind words to the team. So for everyone joining us today, again, let me remind everyone of the rules of the webinar. We kindly ask that everyone keeps their cameras off and mute themselves so we can keep a good quality of the audio and the video for everyone. And if you have any questions, please use the chat function to ask them. After the panel discussion, we are going to use the questions from the chat to ask to our speakers today. Also, feel free to introduce yourself in the chat as an additional networking opportunity within our network. So in the webinar of today, we'll explore the topic of how to use social media to bring the public closer to the court. Judiciaries around the world have been using social media as an institutional mechanism to inform the public about their activities, cases adjudicated, and various other issues for a while. But this process has now gained new speed during the current COVID-19 pandemic. So this virtual meeting aims to discuss examples of how some jurisdictions in the United States use social media platforms to foster judicial transparency and open justice, as well as to generate community outreach by judges and judicial institutions. For this purpose, this webinar will feature a high-level panel of judges and members of the judiciary who will share their techniques and experiences from a practical point of view, as mentioned, as a sample discussion on the potential for the institutional use of social media. The ethical use of social media by judges and open justice and community outreach are already included as priority areas in the work plan of the Global Judicial Integrity Network. On the first topic, we have published a set of non-binding guidelines to provide ethical guidance to judges on how to use social media, which I hope that many of you are already familiar with. And it's available on our website in various languages such as French, Arabic, Korean, and which we are also very thankful to the various judiciaries who have provided the translation themselves. The network has already started to work on these topics, and we are committed to continuing these efforts this year to further support judiciaries in their efforts to promote open justice and the debate on examples of how judiciaries can use social media platforms and other information technology tools to bring the public closer to the courts. So allow me to present the excellent members of our panel today, who with their extensive experience and knowledge will guide us through this topic. First, we have Chief Justice Bridget McCormack of the Supreme Court of Michigan in the US, Presiding Judge Stephen Dillard of the Court of Appeal of Georgia, and Director Craig Waters, Public Information and Public Affairs Office of the Florida Supreme Court in the US. Dear panelists, thank you very much for being with us today, sharing with all of the participants of the network your vast experience and practices. We'll start the discussion by asking a specific question to each of the panelists, And then we'll ask another one that is common to all of the three panelists to encourage the discussion. And finally, we'll open the debate to the questions from the public through the webinar chat function. Thank you all very much for following the rules of participation in the webinar. And so now we'll start the panel with the first round of questions. So the first round of questions, we'll start with the Chief Justice, Bridget McCormack. Justice McCormack, as the Chief Justice of the state of Michigan, you're active on social media platforms such as Twitter, and you have also published together with Judge Dillard an article entitled "The Robbed Twitter, Two Judges' Views on Public Engagement." In this article, you indicate that the judiciary is in many aspects the least understood branch of government. And so you consider that social media can be an ally to engage with the community and promote public education about the work of judicial institutions. So based on this, why do you think it is important to inform the public about the work of judicial institutions and make them more transparent? Do you think this has an impact on public confidence in the judiciary? And could you provide us with some concrete examples of how the use of social media by you and your judicial institution is trying to accomplish or is actually accomplishing all of this? Thank you so much, and the floor is yours, Chief Justice.
Well, thank you very much for inviting me to join with all of you today, especially with my esteemed co-panelists. This is going to be a fun conversation, and I'm really grateful to be part of it. But yes, Judge Dillard and I wrote that piece and have spoken on this topic together a number of times because we both feel pretty passionately that judges and courts should be engaged with the public for a number of reasons. Like you said, we are the least understood branch, but in addition to being the least understood branch, we're the branch that most of the public interacts with. And let me just give you a specific example from my state. In Michigan, the trial courts hear between 3 and 4 million cases a year. Michigan only has between 9 and 10 million people in the state. That means an awful lot of people interact in one way or another with the judicial branch directly, face to face. They have to resolve some problem in a court. And as you know, most people don't go to court because they're celebrating something. Usually they go to court because something has happened that is difficult, maybe traumatic. And the more information the public can have about the way the judicial branch and the courts in particular in our state operate, the better their experience might be. And I always say courts, have to rely on public confidence. It's the only currency we have. We don't have an army. We don't have any money. We can't print any. All we have is the confidence of the public in the role we play in our government. And you build that confidence by being transparent about what we do, by showing the public the ways in which courts can connect them to resources, even when things are difficult, and by demystifying what it is that happens in courthouses and courtrooms around the state. So I'm personally active on social media platforms as a way to allow the public to know who I am. I'm right now the person my colleagues and the voters have entrusted to lead this branch of government. I feel like therefore the public has a right to know what I'm up to and who I am. But my court as well is extremely active on social media. The Michigan Supreme Court has a Twitter page, an Instagram page, a LinkedIn page, a Facebook page, and regularly posts about things each of the courts of the state is up to. I could go on and on, but we have two other fantastic panelists. So why don't I stop right there to make sure everybody has a chance to weigh in.
Thank you. Thank you so much. And these are very important points that you raise, especially about how this is the confidence from the public is really the currency, the legitimacy of the judiciary as well. So I'm sure that we are going to revisit these points very soon in the discussion. So now we'll move then to Judge Dillard. Judge Dillard, you are also the co-author of the article we mentioned, along with Chief Justice McCormack. So in this sense, you indicate that social media also enhances the ability of the judge to do his or her job, either because it helps judges understand the variety of technological issues before the courts or the consequences of the use of social media by their communities, but also so judges can be involved in the communities they serve. So could you tell us more about the increasing need for judges to understand how social media platforms work in practice? And furthermore, you mentioned in your article that many judges today still have concerns about the use of social media because they believe that having a social media presence could undermine the public's perception of impartiality, could be demeaning to the office, or that a gaffe or misstep of a judge could be amplified by using social media. So how would you address these concerns? The floor is
Well,
yours.
okay, thank you. Well, it's great to be with all my friends internationally. It's wonderful to be a part of this seminar with my dear friend from Michigan, Chief Justice McCormack, who I think is one of the most outstanding public servants and jurists in the United States and no doubt throughout the world. Also, my friend, Mr. Waters, who has done an incredible job of reaching out not only to lawyers and citizens in his state, but really showing the importance of state bars throughout the United States, really a gold standard on social media. It's a great question. And I think for me, the key, and we discussed this in our article that I wrote with the chief, it's important for judges to, I think, first and foremost, understand that we are public servants. We serve the people. And in the past, Bridget and I have talked about this in the past, when we were coming up as lawyers, judges, were elevated almost on pedestals. You didn't see them much. They didn't come out of the courthouse. And when they did, your interactions with those judges, I think, were very limited. I think what we're seeing with our citizens, I think not only in the United States, but throughout the world, is them understandably rejecting that old version or connection with the judiciary and demanding more accountability, demanding more transparency. And I think it's important that we give them that transparency and give them that accessibility. Social media, whether we like it or not, and there are pros and cons to social media that we see every day, but social media is a way that most people, I'm 51, but I think about my children who are teenagers and my son who's graduated from college now. Look, that's how they communicate. And we judges, you talked about that needing to be comfortable with these platforms. It's not just a matter of, although it is important for us to be accessible on these platforms, it's also a matter of competency. And we talk about that in the article. We have numerous cases that come before us involving Snapchat and Facebook and Twitter, discovery in the United States where there's the exchange of information in a lawsuit. That has radically changed because of social media. And so it's a competency issue, it's a transparency issue. And once again, I think judges especially, I think in some of the introductory remarks, this was mentioned. I think now more than ever, what we see with some of the instability throughout the world is the importance that courts play in ensuring stability and the rule of law. Even in our own country, we saw the role that the courts have played recently and the confidence that the public has. And that is a precious thing. That public confidence that people have in the judiciary is something that really is precious and sacrosanct. Once you put on that robe, the robe knows no parties, no political parties. The robe knows no partisanship. Once we put on that robe and we become judges, we become trustees of that confidence for our courts, and not only for our states and the people we serve, but really nationwide and worldwide. Because when one judge acts out or acts in an unethical way or acts arrogant, it really harms all of us. And one of the things the UN does, I think, nicely is to show how interdependent we are. And so I think I love this conversation. I think it's wonderful. But I think judges being on social media, when it's done right, I think it can be crucial to building up confidence in the judiciary. And my friend from Michigan is a wonderful example of a jurist on Twitter that can show that accessibility while still maintaining the integrity of the bench. And I know we've got our friend, Mr. Waters, and I want to hear from him because he's a rock star. But thank you again so much for having me. It's an honor to be with all of you today.
Thank you so much. And again, I'm already taking notes of a lot of issues that you already raised. And I think that the point you raise about when people see a judge doing something wrong, they don't see that only that specific judge, right? They see the whole judiciary. So that's why it's very important that communications are done right, that the use of social media is done right. Because also, as the two of you have mentioned now, when it's done right, it has a huge impact in the confidence in the judiciary and in the positive relationship between the judiciary and the communities they serve. So we'll now move to Director Waters for the end of this first round of questions. Mr. Waters, you currently serve as the Director of the Public Information Office of the Florida Supreme Court, which is a dedicated communication office within the judicial institution. And this is a relatively new trend, but we have already seen that many judicial institutions have integrated or are in the process of introducing into their judiciaries a public information office to communicate with the media and increase judicial transparency. So in your role as a public information officer, how do you evaluate the changes that social media has brought to the way that courts communicate with the public? And what tasks would you recommend that judges leave to public information officers, and how judges can best liaise and coordinate with them? Would you have any specific guidance on how judges should use social media? Oh, the floor is yours.
But thank you, and I'm honored to be here, and especially with such distinguished American judges here who are trendsetters as well. They mentioned the ethical issues that judges face whenever they're using social issues. And the Florida Supreme Court was very well aware of those ethical issues, which was the major reason why the court decided to set up a public information office as a continuous administrative body of the court, so that there would be a constant presence who was in constant dialogue with the press and to a large degree the public, especially through social media. That builds in some distance between the judges themselves and the communications that are going out. That's very important when you're dealing with specific kinds of issues. 20 years ago, for example, the Florida Supreme Court had to deal with the very high-profile case of Bush v. Gore, which determined the presidency of the United States at that particular time. It would have literally been impossible for the judges of my court to talk with the press, communicate with the public in a consistent way without, in some sense, looking like they had violated ethics rules. The fact that I was there and I was able to make those communications and deal with the press on a continuous basis was a great benefit. So I strongly encourage courts to look into the possibility of getting public information officers, if they don't already have one, so that they do have, as Judge Dillard said, a dedicated public information and communications function. It's very important to help address those ethical issues. The other big reason why I think courts need public information officers is the issue of disinformation, which has become a huge concern in the last few years. It's something that I have dealt with for much longer than a lot of courts, partly because of the Bush v. Gore cases 20 years ago. My court was politically attacked because of the opinions it was releasing in the Bush v. Gore cases. So we had a very early experience with disinformation, with spin, with very negative publicity being put out for purely partisan reasons, attacking my judges and attacking my court. Being in my role with some distance, I was able to address that to a significant degree. But I can tell you, when social media came along, social media suddenly became my best tool for dealing with disinformation and also just regular misinformation. We have had instances where politicians attacked the Florida Supreme Court for their own political gain on issues such as the number of opinions we released every year. Like the U.S. Supreme Court, we only issue about 80 or 90 full written opinions, but we decide the vast majority, about 2,000 other cases, by orders. We had a politician go out and say the Florida Supreme Court is only doing 80 opinions a year, it's not earning its pay. But through social media, I was able, without directly confronting that politician, I was able to get good information out there and quell that. So dealing with disinformation is another big role. And I also would like to say that in the United States, we have an organization of National Court Public Information Officers. It's called the Conference of Court Public Information Officers that meets regularly. We have international members. And if any of you are interested in the different ways that PIOs work in courts, I would encourage you to get in touch with that organization and perhaps attend one of its meetings. And with that, I'll hand the floor back to you.
Thank you. Thank you so much. And we already have some questions in the chat that will help us get back to some of these examples and advice to judiciaries from your experience in Florida. So thank you to the all three panelists for this first round of questions, which I think that set the stage really well for our discussion today. We're going to move now to the second round of questions. So it's one question to the three of you. And then maybe we can follow the same order we had for the first round. Maybe we can start again with Chief Justice McCormack. And we'll hear from the three of you, and then we'll open the floor to the questions from the participants through the chat function. So the question we have now for you is that, as we are seeing in this webinar, there is a real opportunity to advance this discussion, exchange experiences, and learn from those jurisdictions that are already using social media to promote transparency, to be accountable to the people they serve, and use it to engage with their communities. So I invite the three of you to share any good practices, practical advice from your experiences, or lessons learned for those considering an institutional use of social media, and or to introduce a dedicated public information office as part of their courts. So we'll start again with the Chief Justice.
Yeah, thank you so much. So the question is more about the institution's social media presence, which is different from the individuals. You know, the Michigan Supreme Court has, as I said, I think a pretty big footprint on social media and a lot of followers. It does not interact with people on those platforms. It only pushes information out. It pushes lots of information out, information about the Michigan Supreme Court itself. Anytime we're having oral arguments, our Supreme Court social media feeds not only post the link so everybody can watch those oral arguments. That's not only true since we're arguing on Zoom. We always have a live stream link even when we're in the courtroom. But we also post specific information about each case we're hearing, as well as links to where people can learn more about it. In addition to that, the court posts orders and opinions when they come out, and it also posts information about stories happening in the legal system more generally, not just in trial courts, but in sort of like larger legal culture. It will retweet posts from individuals or other organizations, but it does not interact. It doesn't really have a sort of personality such that it sort of interacts with other people. The individual accounts we do. Judge Dillard and I often have playful exchanges on Twitter. I think just the other night I caught him really trying to root for the University of Michigan football team, which is hard for him to do, being down there in Georgia and being a big Samford fan. But he sort of like indicated that basically he's a fan of University of Michigan football. So I appropriately made that clear to all of his Twitter followers that that's what he was doing. And he sort of replied again. So individuals, I think, can have interactions that are playful and fun, or sometimes serious. We learn a lot by interacting with other individuals on Twitter. One of the things I love about it is I've met people who I otherwise would not have met, and now learn from them all the time. Law professors, judges, lawyers around the country and around the world. But I think for institutional platforms, putting information out and not interacting is a best practice. There's lots more to say, but again, I'll let my colleagues have a shot and go from there.
Thank you so much. And maybe full disclosure, we are also following you and Judge Dillard on Twitter. And we also like to see the interactions you have. And maybe we can later go back to this point, but I think one interesting interaction is that you also interact with the public. And if I'm not mistaken, even with maybe musicians and celebrities. I think there was an interaction with a rapper in the US, LL Cool J, which I think it's also an interesting aspect of how social media brings the courts closer to the public. And maybe going back to Judge Dillard's point about how the new generations are so immersed in social media, I think that's also an interesting aspect of bringing the youth closer to the judiciary as well, using this type of interactions. Maybe we can come back to that later in the questions from the audience. But now I'll pass the floor to Judge Dillard.
Well, thank you again. And I don't know that I could improve much on what my friend from Michigan just said. I do think I think she's right to point out, and Director Waters also pointed this out. You really have what I think is the more formal approach to social media, which is through the courts. And I think they necessarily have to be a bit more formal, although the State Bar of Florida's social media account is fun. And it very much does have a personality, and Director Waters has done an incredible job with that account. And like I said, I think it really is, as much as I'm biased to the State Bar of Georgia, I think they really have set the gold standard there. Our court too has a website, and we live stream, which I think I know something that all of us care deeply about, are live streaming our proceedings and letting the public letting the public view their judges in action. I think Georgia and Michigan are big states, and although I am a statewide official and so is the chief, we usually have our arguments, although we sometimes take them on the road and go to different cities. Most of our arguments are in the wonderful international city of Atlanta. And I don't think somebody in South Georgia, in Bainbridge, or North Georgia, in Blue Ridge, should have to drive to Atlanta to see oral arguments or wait for them to come every 5 years or 10 years when we take the Court of Appeals on the road. So I think transparency through the formal accounts, through the website, having an easy website to navigate, making opinions available to the public. Once again, and we say this a lot in our article, it's the people's court, right? The courts are not for judges. The courts are for the people. We serve the people. I think sometimes judges lose sense of that. The fact that, I think when people think of judges, they think of us with the robes on, we're on the elevated benches. But the reality is the relationship is the people are up here. We're down here. We serve them. And I think one of the nice things, shifting away from kind of the more formal aspects with the courts and the public information officers, I think one of the nice things about having wonderful people like my friend Bridget, the Chief Justice of the Supreme Court of Michigan, on social media, is that it shows her humanity. And I think it's important for people to understand that judges are people too. We have lives outside of the courtroom. And while some judges, I think, shy away from that, I think that's a mistake. You can share part of who you are. You can share the fact that you've got families and pets, that you love music, that you love sports. You can do that in a way that shows your humanity without being inappropriate or without diminishing your role. And what I've noticed is when I have people come up to me in public usually lawyers, but Bridget and I have fairly large accounts for judges, but we're nowhere near, as you mentioned, rappers or celebrities. To call us celebrities would be to diminish that word entirely, although I do think of my friend Bridget as a rock star. But when the lawyers come up to me in public, they usually do a couple of things. One, they thank me for the live streaming of our court proceedings. And two, they thank me for showing that judges are people too on social media. So look, I mean, it's never going to be perfect. There are going to be some missteps along the way. But talking about the pros of social media, one of the pros that we may not recognize that can be a con and a pro is when a judge does misstep on social media in a bad way, and there's a reaction to it by the courts as institutions and the disciplinary boards to address that misstep, that too can end up bolstering the integrity of the judiciary. And sometimes transparency reveals what it reveals. And sometimes social media ends up revealing that certain people who are judges ought not be judges. And so there's a lot more I can say about this, but I think the fact that you have these different ways of interacting with the public, the more formal way through the courts and the more individualized way through the judges, I think both of those work together to promote confidence in the judiciary when done well. And that's an obligation I think we have as judges to make sure that we're doing the right things on social media, we're projecting the right image, and that we are being accessible to the people we serve.
Thank you so much. And I think you raised very important points about how the cons of social media can also be turned into pros, how even the misuse of social media can have an educational effect and show that transparency is really working. I think that from our work in the Global Judicial Integrity Network, we see that a lot of judiciaries and judges, they're very worried about the misuse of social media, that sometimes they forget on how to really promote the good use of social media. So I think that this debate can provide some a lot of good insights also to that direction on how to really promote the good use of social media. So Director Waters, now I pass the floor to you.
Great. Well, thank you so much. Judge Dillard raises a wonderful point about showing the humanity of judges on social media. This is something that we have been doing for quite some time, even on our formal accounts. I like to do anniversary events, the anniversary of someone being appointed to our court, for example. And we will put in biographical information about the judges and their history. One of my judges, for example, who currently sits on the Florida Supreme Court, had 4 daughters of his own, he and his wife. His daughter was very involved in foster care, and they came across a sibling set of 6 brothers who were about to be broken up and divided among different families for adoption. They adopted all 6 of those brothers, making their total number of children 10. And I often bring that up as a way of showing, the human side of the judges who currently sit on the Florida Supreme Court. At the same time, I totally agree about the issue of judges who are involved in ethical misconduct. One of the first things we did when we started using social media in 2009 was we began notifying the press and the public about a huge variety of filings that come in to our court that are considered high profile. Among those are judicial discipline cases. So the public and the press were able to see from start to finish the way that judicial misconduct was dealt with, and they were able to see a system that was working effectively. So that was extremely important as well. And so I think it is absolutely crucial to to do these sorts of things. I'd also like to just mention that we do not use our official accounts to interact with the public either. I think both the speakers are right on point with that. On our Facebook use policy even says you cannot transact any court business using Facebook. And we have similar statements on other social media. And of course, among those official uses would be requests for public information or public records, which are governed by court rules in Florida. So we give information for how people can correctly file public information or public records requests, but we do not use social media to interact. But I do monitor social media carefully. I monitor everything that is posted about the Florida Supreme Court. And if I start to see a negative trend, I will get together with my team and we will consider whether we need to develop one or more social media posts to address the misconceptions or disinformation that is being spread about our courts. So that is one way that we do address issues, but not in an interactive way. Thank you.
Thank you. That's a very good example on how to use it, and very also important to raise that the institutional channels of social media are still official channels of communication of the judiciary, and so they should be used for that purpose instead of creating a direct interaction with people, which can be misunderstood, can backfire, can create all sorts of problems, even in raising, again, questions about the impartiality of the judiciary and lowering the trust. So that's a very good example. And Director Waters, you already touched on one of the questions we have from the chat, but maybe we can go back to some more examples on how to treat misinformation, or as we have on the chat, trolling. So maybe we can go back to a few other pointers from your experience. So thank you all so much to the three panelists. With this, we concluded the rounds of questions from the moderation. We are now going to start asking you the questions from the participants, as we have on the chat. So in this case, unless the question is already directed to one of you, I will ask that you decide amongst yourself who would like to volunteer to be the first to answer, if you want to answer, or if you want to later complement or add additional points to an answer, please feel free to do so. You can just unmute yourself and answer the question if you want it. And if the question is already directed to one of you, I will specify. So for this next round of our discussions, maybe we can start with a question is that if you can provide concrete examples of how the use of social media and by you or your institution is accomplishing or trying to accomplish this greater confidence in the judiciary. So any anecdotal examples or even institutional examples of how you could see maybe an increase in the satisfaction from court users, or if you've seen an increase of confidence in the judiciary. So if you can give additional examples, that's one of the first questions you have.
I'm happy to tackle that. My friend from Michigan had to go first every time, so I'm happy to do that. I would to give some concrete examples. I know that both the chief and I will frequently tweet when we are having oral argument. We will tweet a link to our followers to say, hey, we're having oral argument today. If you want to tune in, here's the link. I think that's not only important for the citizens we serve, but not every state has live streaming of oral arguments at the appellate level. So I think that's educational to people in other states. I've watched live streams of other court proceedings in other states. And going back to one of my friend's earlier points, we learn from each other. And I know we co-wrote the article, but I have to credit my friend from Michigan for coming up with this kind of this national, I think she called it a national live national learning lab, that we learn about best practices from each other. So that is one way that I think social media a concrete example of how social media, I learned something that the Supreme Court of Michigan is doing, and I can then take that and apply it to our court. Some of that might be our live streaming of oral arguments. Some of that may be the way I start looking at their websites and getting ideas from, oh, they're doing this and they're making it easier to access information. Maybe our court ought to do that as well, or maybe they learn that from us. I think in addition to those sorts of things, I know that the chief and I have both done podcasts together where we talk about judges using social media. We tweet that out to our followers. I've written an article for the Mercer Law Review about demystifying the inner workings and culture of the Court of Appeals. And so, you know, some of the traditional methods of accessibility and transparency still work, but you can use social media to boost those, you know, to provide a greater audience. So law review articles don't always, you know, get a wide circulation, but the article that I co-authored with my friend from Michigan, we share that on social media. That helps other judges. That's a concrete example. It gets a wider audience through social media. My article in the Georgia Court of Appeals, same thing. And I've had other lawyers from other states talk about what a unique article that is. I mean, obviously, I'm not talking about court cases in that article, but I am talking about, you know, in general, how do I go about opinion writing? How do I go about preparing for oral argument? What am I looking for with the briefs? That benefits lawyers. It benefits other judges to see how another judge, I mean, all of these things, I think, sharing podcasts, sharing legal writing articles, having question and answer sessions on social media with lawyers, providing advice, being a mentor. I'm a mentor to lawyers and law students throughout the United States and even internationally. I've had international lawyers contact me and ask for advice about coming to the United States, and that's the amazing and transformative to me aspect. And that's why I love that we're doing this with the UN. Social media really brings us together as a global community. And so social media really allows us to do that. And if that's not a concrete example of us, you know, showing the pros and benefits of social media, I don't know what else is. I mean, bringing that global community closer together and learning from one another and sharing our commitment to the rule of law, I think is a marvelous and wonderful thing.
I have one concrete example to just to give you a sense of how it can have an impact. You know, there was a lot of litigation in Michigan, Georgia as well, after the election. And in one particular, and I won't be commenting, of course, on any of those cases, but in one particular case, the trial court, which here in Michigan is called the Court of Claims when it's a lawsuit against the government, was holding a hearing on that lawsuit, and because the hearing was on Zoom, it was although we could have done this if the hearing was in the courtroom. The court put on every social media platform the link to be able to witness that hearing. And at one point, there were over 8,000 people watching one hearing in a trial court. That's kind of stunning, right? If it were happening in a courtroom, people might have read about it afterwards. Maybe a couple people would have gone to the courthouse to show up and watch it. But because it was, because we could link that stream, it's scalable to infinity. Anybody who is interested in seeing how the court is handling this particular case gets to watch it. That's kind of a wonderful feature of being able to communicate with people through social media platforms, giving everyone access to what your courts are doing.
Yes, and I would like to echo those remarks as well. Openness works, open justice works, transparency works. We have found that to be true time and time again. The biggest communications challenge I ever faced in my 34-year career at the Florida Supreme Court were the Bush v. Gore cases. Back then, we live streamed the arguments from start to finish on a worldwide basis. If you go back and look at the scholarly articles, the books, everything that came out of that period, you will see a consistent trend of people saying how impressed they were watching the arguments at the Florida Supreme Court and realizing they were not political arguments. They were legal arguments. And I really think that that saved the Florida Supreme Court during that period of time from a lot of misunderstandings that could have occurred otherwise. Of course, since that period of time, we have moved into social media, and we now broadcast our oral arguments live on Facebook and YouTube, as well as a number of other means through different media as well. And so that makes a huge difference as well. And I really think that that's one great example of how you can use social media to let people see the inner workings of your court so that they don't indulge in misunderstandings or believe disinformation about your court.
Thank you so much. And these are all very interesting examples. And Director Waters, also your example reminds me that some judiciaries, not only they have a public information office, but they also broadcast on television some of their hearings and have been doing so for a while. But I think that with social media, judiciaries can really broaden the pool of people that have access to the information. Usually such TV channels are private cable channels, and not everyone would have access to, or not everyone would be at home at the time of a hearing to be able to watch it. So I think social media also brings that flexibility that it's a step further in the transparency. But maybe to again ask the three of you if in the institutional use of social media, if you have any ways to measure the impact that the use is having in maybe the confidence in the judiciary or satisfaction of the court users, if there's any survey, any type of mechanism to measure this impact.
I can go first again, although I bet there probably are people who are better experts on this than I am. There are surveys that the National Center for State Courts does in the United States about the public's confidence in the state courts. But I don't, and I happen to sit on the committee that puts that survey together, but I don't believe we have targeted or asked to be able to measure the relationship between a particular court's social media presence with public confidence. That the survey is a national survey. But I do think it's, one of the things we do measure, of course, is the interaction people have with our institutional sites. And I'm sure the Florida Supreme Court does this as well. So we know how many people interact with a particular tweet, how many people interact with a particular post on any of the platforms, and we know that it's growing. For whatever it's worth, the National Center's survey of the public regularly records, even in the last couple of years, when there has been higher mistrust in government generally in the United States, people have confidence in their courts at a higher level than in the other branches of government. I don't mean to throw shade on my friends in the other branches. Keep doing what you're doing, but the public's confidence in the courts is higher. Now, one topic we have not talked about, although we have in a way, is the interaction that judges and courts have on social media platforms is really different than the interactions people can have who are elected to partisan branches of government. As Judge Dillard said when the robe goes on, we are not partisans. It's pretty important. And frankly, I think even when the robe's off, he and I would agree that we're not partisans because we are judges now. And so our interactions, I think, on social media platforms are almost always positive. We aren't in some of the negative interactions that you might see from other electeds in partisan branches of government. Not all, of course, but some. And so that I think also helps build confidence. But of course, there's tons of data on transparency and public confidence in lots of institutions, right? So there's no reason to believe that courts are different from other institutions where it's clear that the more people understand about what is happening, the greater confidence they have in the decisions made by those institutions. But maybe my friends have better data on specific public confidence trends and social media use.
I don't, and I don't know that I can improve upon my friend's answer. We track, obviously, who's watching our oral argument. We have some analytics on our social media accounts. Some of it's anecdotal, but, you know, I think the key is, you know, and once again, the interactions are going to be different. They're going to be much more limited with formal court accounts with ours. But I mean, you can look at our follower accounts. You can look at, you know, I think most of the interactions we have on social media as judges are positive. So I don't know that I have any data beyond what the chief just talked about, but I think as we move along, you will see more and more. There's a lot of law review articles that are starting to be written, and that gives us a little bit of a gauge of the scholarly reaction to judicial judges participating in social media platforms. But you know, I think it's evolving. I mean, even though I've been doing it now for a decade, you know, we're seeing more and more judges are participating on social media platforms. And I think with that, we'll start to see more data. That's my guess, at least.
Yeah, and I agree, of course, with both of the judges here. We at the Florida Supreme Court, we use analytics very closely. There are analytics built into almost all of the social media tools. It takes a little time to learn them. We have staff that really monitors those, although I go behind them and I will look at what they are doing. We also use tools like Hootsuite to assist us in posting on social media. They have built-in analytic tools that are very helpful in you being able to see the scope and impact of particular types of issues. We have often been surprised at the kinds of tweets or Facebook posts that get attention. To date, the one post that has gotten by far the most number of hits, it got 300,000 hits, was a post we did on the right to counsel case, Gideon versus Wainwright. I was surprised because I thought that was law school material that a lot of people might find boring. But we wrote it as a David versus Goliath story, and I think that's what made it, you know, very, very popular with people. At the same time, I have to comment about the negative remarks you get on social media. We get those, as everybody does. You'll get trolls. You'll get people who will say outrageous things. Sometimes we get people who will put up commercial advertisements for their business. And we do monitor those. We do not engage people. Our view about chatting on social media is that it's for the users to chat among themselves. It's not for them to chat with the Florida Supreme Court in any official manner. But we also have policies that deal with particular types of issues that we will remove or hide from the comments that we get. And that's especially true on Facebook. Our policy is to hide any kind of commercial comment that is essentially an advertisement that's not related to what we are posting about. So we will hide those. And for those who don't know, in Facebook, if you hide something, it still can be seen by the person who posted the comment and their friends, but it cannot be seen by anybody else. So we are essentially limiting their audience. Our general counsel has given us an opinion that is consistent with the First Amendment analysis on a limited public forum, which we believe social media is. So that's one way that we address these negative issues. Thanks.
Thank you. Thank you so much to the three of you. And maybe Director Waters, I'll use your response now as the link to the next question, because we have a couple of questions in the chat on additional tips or suggestions as to how to address trolling. I think we've already touched upon that. And how the institutional use of social media can help defend judges. So if it's not a comment that it's a general comment against the judiciary, but if these are attacks targeting a specific judge, We have some comments here that in some jurisdictions, the communications department or the judiciary decides to not engage into those situations as well. But maybe if there's any suggestions or tips on how to address these situations.
Right. Well, we address those in our user policies, and in the United States, we of course have the First Amendment, and First Amendment law is fairly well defined at this point. One of the things that our general counsel believes is that we need to have a written policy, which we do. We post on our social media accounts, and we tell people in advance what kinds of comments will be removed. One of those in our list is attacks on other people's, and also partisan comments or comments related to someone running for public office. So those are the kinds of comments that we would hide on Facebook, so that only the person who posted them and their friends would be able to see it. We do understand that social media is a limited public forum. People have a right to engage in it in a limited way, and we let them do that. But I can tell you, I know what many of you in the courts out there are thinking. In the very early days in 2009, when I first started using social media, I had judge after judge come to me and say that this is the Wild West. People are saying crazy things. You can't let this happen. And I really had to get over that hurdle. And it has taken me 12 years now to get my judges to the point where they are comfortable with the idea that there will be vigorous debate on social media, but we do not have to engage in it. We can let people talk among themselves as we would let people talk on the street. But we have to develop a tough skin. At the same time, though, I will tell you, I do follow negative remarks. And if I see a trend, I will develop some sort of social media post that independently responds to that trend. Thanks.
Thank you. Thank you so much. I think that's very useful guidance. Chief Justice, you'd like to add as well?
Well, I was just going to mention that I don't, when there are particular specific attacks on a judge, no, the Michigan Supreme Court doesn't sort of take those on. I think we follow the Florida Supreme Court's approach. But like with everything else, the best defense is a good offense. So one of the things that you hope to establish by having a positive social media presence is taking the sting out of those attacks when they come, or the disinformation attacks. Even apart from the specific attacks on a specific judicial officer, there are just more general sort of disinformation campaigns that are going to be less effective if you have been successful at being transparent and positive and showing the public how courts work. So when those, problems come, you're in a much better position to answer them. You've already established yourself in a way that the public understands.
I agree with that, and I would just go on to say that, I think that goes to your reputation. If you are engaged with the public, if you have shown the public that you care about accessibility and transparency, a lot of those folks are going to defend you. You don't have to defend yourself, because people will be invested in you because they trust you and they believe in you, and you've established your reputation. But one of the things we talk about in our article is the fact that you have to distinguish between trolling and fair criticism. If someone tweets at one of us and says, I'm really having a hard time navigating your court's website or this aspect, or I'm having trouble, once is criticizing something at a very general level and that is not case specific, I'll respond to them, and sometimes I'll have lawyers say, look, I can't access your e-filing system. I'm having problems. And they'll send me a message, and I'll send them the number. I'll say, get in touch with this person at our court and they'll help you. I think that's perfectly fine. I don't think there's anything wrong with that. And so once again, social media is a way to be responsive. And when you do that in a public way too, I think people are watching, and it shows that you are attentive, and that once again, you're a human being, and that you're doing the best you can to be a public servant. But I could not agree more with both what both of my colleagues have just said. I think, there really is, it's important for the courts not to respond, but I think judges can respond. But there's the old saying, don't feed the trolls. Don't engage. I mean, people, we're usually, I think we're all smart enough to figure out who's engaging us in good faith and in bad faith. And if you engage someone and then it becomes clear they're not engaging in good faith, then you just withdraw from the situation. You just don't respond anymore. That's at least been my policy over the past decade.
Right. And Roberta, if you wouldn't mind, I'm going to post a link to a document that was produced fairly recently by the National Association for Court Managers and the Conference for Public Information Officers that covers some of these issues, and I think could be helpful to people if they need a takeaway printable resource. I think this is a good one. It reflects a consensus view among court managers and court public information officers in the United States about best practices.
That's wonderful. And if you don't mind, we'll also be adding this to the website of the network. So it's not limited to those attending the webinar today, because I think that this could be a very interesting and useful resource to all judiciaries. Thank you for sharing that. And maybe one more question from the chat. Now I think it would be specific to Judge Dillard and to Chief Justice McCormack. And we have a question about, have you encountered any objections from your colleagues regarding the use of social media? And in that case, how did you address and maybe convince those colleagues of the benefits of the use of social media?
Oh, I have a great story about this one that I'll tell very quickly, then I'll turn it over to my friend. I might have been out a little bit earlier than my friend from Michigan on social media. I was appointed in 2010 by Governor Perdue, and I set up my account right after that. And shortly after I set up my account, some of my colleagues who were a bit older, once it started gaining popularity, they would give me kind of a hard time. And some of the justices on our Supreme Court would give me a hard time about being out there and becoming what they called a Twitter celebrity. But the best part was when the Supreme Court of Georgia's public information officer came to me for tips on setting up their court's, social media accounts. And I didn't give them too hard of a time, because I appreciated that they finally came around and started to see the value in courts communicating with the public through social media platforms. But it really is remarkable in just 10 years to see how there were a handful of judges, at the beginning doing this. Now, a lot of courts were live streaming for quite some time, and including the Georgia Supreme Court. They were live streaming long before my court. I really had to fight some of my older colleagues to get that done, just because, they were like, live streaming, it just seemed like a foreign concept. But I do think we've come a long way. And I think that there was a lot of resistance at first. I think there is less resistance as we start to, you were talking about data earlier. Anecdotal data is sometimes the most important data for judges, because when they start hearing things from lawyers and others and citizens, you mentioned the response back with the Bush, v. Gore, with, people being impressed with Florida and the transparency. My mom, as we like to say in the South, and my mom likes to say, doing the right thing is good politics. And being transparent, being accessible, that's good politics, and it's the right thing to do. And so I think over time, a lot of my colleagues who were skeptical about Twitter and social media platforms have come around. And as our friend, Justice Don Willett, who's now a federal judge, has said, often before he went to the federal bench, if you are an elected judge, and many of us in the United States and the state court system, most of us are, if you are, it is political malpractice to not be on social media platforms, especially in down ballot races, when you're not going to have the kind of money, you're not going to have You're just not going to have the kind of exposure as the races for governor and other races at the top of the ticket. So the only real way you can reach out and do that is to do that through social media platforms. And if you're a down ballot candidate, like many of us are, even in an important race like the Supreme Court of Michigan, the campaign, in a sense, never ends. And once again, it goes back to what I just said. Doing the right thing is good politics. You can run for office with integrity. You can be on social media with integrity. And if you do it consistently, then you're campaigning without campaigning. And I think that's good for the judiciary. And it promotes the courts, and you end up promoting yourself as a result of that. And I don't think that's a bad thing.
Yeah, it's a good question. The Michigan Supreme Court has 7 justices. There are 3 others who are on social media pretty regularly. The other 3 women. The 3 men, I think, have accounts that maybe from whenever their last campaign was, but they're less active. And I am confident that, maybe when I was new to the court, which was a little over 8 years now, there was some skepticism of my presence on social media, but the court then hired a public information officer who with the goal of having the court increase its presence on social media, and we talked about it at the conference table. And I now don't think there's anybody on my court who doesn't see the benefits of the court bringing transparency to the branch through its social media platforms. That doesn't mean that it's for everybody. Like I said, I have a couple of colleagues who I don't think spend much time on social media platforms at all. And even if they did spend a little more time on, they probably wouldn't, might not be as comfortable as I am with some of the personal interactions and personal revelations that I am comfortable with. But that's okay. I think everybody has come to see the benefits to the public in bringing the courts to people where they are. I think, as Judge Dillard said at the top of the program, a lot of people get most of their information now on social media platforms. They don't open up a newspaper in the morning; they open up their Twitter feed. So if we want to make sure that people know what we're up to, we need to be present in the places that people are looking for information.
I think that's a very powerful point that you make about being present where people are looking for the information. I think that's also the best way to make sure that the information does reach the public. I think that's a very good advice as well to other judiciaries. And thank you both for these very interesting examples. So maybe now one question to Director Waters from the chat. We have one question here about the public information officers. So should they or must they be legal practitioners who liaise with a panel of judges before the information goes back to the public? So what is the type of background, the skills, and for the work of a public information officer? I think that's the curiosity in the chat.
Most of them are not lawyers. I'm one of the unusual ones who is. I've had a law degree for almost 35 years now. And I really got into this by way of being a staff attorney at the court who sort of evolved over time into being a public information officer because my court kept getting controversial. But most of the public information officers usually have a background in media that usually was in some way connected with the courts. For example, they wrote about the judiciary when they were working for the local newspaper, or they did stories in the local radio or television station about the courts. That's the most common background. But I can tell you, one of the things that we do, both in the national organization that I'm part of, and in Florida's own version of our statewide organization, is we have intense training programs for all of our PIOs that not only talk about the technical aspects, the public relations aspects, the technology aspects, but we also talk about the legal aspects. We will bring in top name lawyers to go over First Amendment issues and other matters. In Florida, we have a very complicated public records laws. So we do a separate training track for that for our Florida PIOs. But these national organizations and the state organization that I'm part of play a big role in training all of our PIOs in what they need to know. So we both of these organizations are nonprofit educational organizations, and their primary goal is to educate members of the profession.
Thank you so much for that. And now maybe a question for the three of you that we have here on the chat. So a number of judges are concerned about personal security when using social media, especially when sharing private information about their families or personal interests. Do you have any recommendations on how to address these concerns from your experience?
I guess, those are concerns for judges in real life and on social media platforms, just like, we often hear from judges who worry about ethical lines on social media. And I always say, you have those same questions when you go show up at a Rotary Club meeting or a state bar meeting and you've been asked to talk to the members about some topic. You have to be mindful of where the judicial canons allow you to wander and where they don't want you to. You do the same on social media. Sure, one problem is if you misstep, a lot more people might see it, and it might be preserved in perpetuity. And so, maybe be extra thoughtful or careful, but it's nice that you get to actually think before you hit post in social media. Sometimes when you're in person, your lips are moving and you don't have the time to think before you post. But I think security is the same way. Security is a concern for judges in general, and it's a concern when you're out and about addressing groups in public, and you make decisions about how much to reveal about your personal life. And I think everybody has their own comfort level with that. I don't think it's any different on social media. For some reason, I think lawyers and judges are sort of slower to tech innovation than maybe any other profession out there. And so we sometimes fear the unknown in a way that I think is understandable, but I don't think that the decisions you have to make that impact personal security are any different online than they are in real life. It is easier for, as we've talked about, trolls to find you and target you. It's harder for somebody to come to my house and leave a nasty letter on my front porch than it is to send a reply to a tweet that's kind of nasty. That's easier. But I don't think the security concerns are categorically different. I think they're the same.
I agree with that. I mean, I think the kind of in real life and social media distinction, there's always security risk, right? And so in a way, you could argue that social media, being on social media and being available to be yelled at by your constituents, even if you're not engaging them, in a way might enhance security because it allows people to blow off steam, without actually coming to your house or trying to confront you in public. I don't know. I always say, and we said this in the article, judges are different. We're not special. I know our presidents, their families are, out in public, and unfortunately, I think the further you are down ballot, maybe the less folks care about that. But, I share things about my family and my dog who's waiting for me to throw another treat here on social media. And I think once again, it's a way of humanizing you to the people you serve. And so to me, the benefits outweigh the risk. I think the risks are largely de minimis. But, things you could do is you could do what's, for Instagram, you could do a latergram. You could kind of, go to your events and then post about them later. There are things you can do. You might not want to show folks that you're checking in on Facebook. You might want to, do it later. I mean, there's things you can do, but the truth is, I don't have like a security detail. I think if there were ever really a risk, the state would provide me with one. But, at the end of the day, I think the risks are what they are. And I don't know that social media necessarily makes those risks any greater. At least that's not been my experience. Like I said, I think the ability, I never block people, especially from my state, even if they're being abusive to me, because my view is these are my bosses. I'm going to let them vent, hopefully get it out of their system. But I don't know that there's an easy answer. But if you go to the Rotary Club, the Rotary Club's probably going to announce that, and you have a security risk there as well in real life. So once again, I'm not sure. Social media may make it easier for people to track you. It may also make it easier for them to criticize you without having to track you. So I don't know. I think it's just, these are issues we have to face as public servants. It's the same for our friends in the legislature and also the executive branch as well.
Yeah, and I would have to agree with that. I get it. Don't share personal information on social media if you would not share it elsewhere on the webs, and particularly information that could be used to track you down, and especially if you're in the middle of something high profile or controversial. But in that vein, I would also like to add something that we have been doing at the Florida Supreme Court for the 25 years that I've been its public information officer. If something embarrassing happens, a mistake is made, an order is accidentally issued when it shouldn't be, and we have to go to the public and confess that we did something that was not correct, my face and my name go on that. My judges' names, faces and names do not go on that. It's part of my role as the public information officer to be the person who tries to deal with the difficult problems that sometimes happen in administration or otherwise with courts. We certainly saw that during the Bush v. Gore period 20 years ago when I was the one publicly announcing very controversial court decisions, so that the attention to some degree was deflected away from my judges. As a matter of fact, I ended up being the one with the security detail back then, and not the judges of the court, and they liked it that way. But keep in mind this role that your public information officer can play in helping to deal with controversial or embarrassing problems.
Mr. Waters, I think now we're going to see a surge in the interest for public information officers after this last point you made. But thank you so much to the three of you for this. And from your points, I think it's also linking back to one of the things that we have in the guidelines for the use of social media that were developed within the network with consultations with judges around the world on how judges really need to be trained on the use of social media so they understand the risks or the heightened risks, but they are not different from the offline risks that they already have in their positions, and on how the international standards or the codes of judicial conduct, they continue to apply to the judges to guide them in this new environment of social media. It's not so different. It's a matter of understanding the specificities of social media, the heightened dissemination, the quick interactions, the amplification of the interactions, but it's not so different from what judges already have to think about or consider in their own behavior offline, whether in court or in their private lives. So we are almost at the end of our webinar, and I wanted to ask maybe one last question to the three panelists, but please feel free to answer that one if you want. We spoke today about also measuring the impact of the use of social media. So we heard about the number, tracking the number of followers, tracking the interactions. I also mentioned in the first round with Chief Justice McCormack the engagement with maybe not such a regular users of the court or people you wouldn't normally interact as a judge, like celebrities or others with a greater following in social media. So maybe I wanted to combine those two to address again the issue of reaching the youth. Have you identified any rise in the interest through the ways that you track social media interaction from younger users? Have you identified any greater interest from younger users on how the judiciary operates, on what it means to be a judge? And now maybe specifically to Chief Justice McCormack, especially to young girls. Have you any anecdote interactions or experience? We've seen maybe young girls having a greater interest in the work of a judge, in the work of a chief justice, and being also encouraged by that. So maybe this question to finalize our panel.
I think that's a great question. The young people are not on Facebook. That's really only for like old ladies like me. And they're not on LinkedIn. There are some on Twitter, but honestly, they're on TikTok and Snapchat. So I think, and Instagram, my Instagram profile has more young followers than my other accounts. And the Supreme Court's Instagram account is aimed at bringing information to a younger audience. I have not really figured out TikTok yet. Judge Dillard and I are thinking about it. Excuse me. And I am only on Snapchat to see if there are like things I need to know about my kids. So I think I could do better in the area of reaching young people. I wonder what my friends think.
I think I agree with everything that my friend just said. And we are talking about TikTok and other platforms. And that's the thing. Every time a new platform, I start to see a trend about it on Twitter, which is my main social media platform. I always want to check it out because you don't want to eventually join to the point when the young folks have left. The more you have older folks join a platform, the less the younger folks want to be there. TikTok seems to still be fairly relevant, and we've talked about doing some educational videos on that platform. I've done kind of an initial video. It's really just showing my chambers. That's about it so far. But to go back to a previous point, I do think law students and high school students are still younger folks, and I am active in high school mock trial, which is a program we have in the United States where young people from high school actually learn about the judiciary and actually get to do virtual arguments as, kind of a mock proceeding, them acting as lawyers and jurors and everything else. So I do get an opportunity to mentor those folks, and I think that's important. That's probably, to me, one of the best things to come out of me being on social media is being able to mentor college students and law students and even some high school students. Now, obviously, as a judge, you got to be careful. I would say any interactions with high school students need to be out in public. I think I'd be real leery of doing too much. But if they're law students, college students, you need to think about every interaction, whether it's private or public, and you got to be careful with all of that, because once again, you have to protect your role as a judge. But I think mentoring students is an important part and an obligation that we have as public servants. And I think social media has dramatically transformed our reach and our ability to mentor young people. So I think that's crucial. But we do have an obligation to educate the next generation. And I think social media platforms are going to play a large part of that. The one tip I will say that I would give all the judges who are thinking about doing this, authenticity matters, in your, I think if Bridget, I think would attest to this, and I can do it for her. I haven't spent as much time with Mr. Waters, Craig, my friend, online friend, but I would say Bridget would say about me, and I would say about her, pretty much what you see on our online personalities is pretty close to what you get in real life. Now, obviously, you're putting your best foot forward, but people can tell if you're being authentic. And so you need to think about what you're posting about, what you care about, and you need to kind of stay on brand. That doesn't mean be inauthentic, but talk about the things you're passionate about. We care about civility, transparency, accessibility. I care about music, sports. My alma mater, Stanford University, I talk about it a lot. I mean, you need to stay on brand, and you need to let people know who you are as a person. Once again, social media allows us to show the humanity of being a judge. And I think authenticity is important. Don't go on social media and try to be something you're not. If you don't care deeply about the Oxford Common, legal writing, and all of that, you're going to get into interactions, and your lack of knowledge, or either something you don't really care about, is going to show. And so you need to talk about things you care about. And I think if you do that, you're going to gain a following, and you're going to have an opportunity to help build up the reputation of the court and yourself to the public as well. So those are just some thoughts I have.
Great. And I would just like to say that we have a very successful tour program that's run by my office. It originally was simply based in the Florida Supreme Court itself. When the pandemic hit, we actually moved it to a virtual format, and that has expanded our audience tremendously to school groups really all across the nation, and even as far away as Canada now have come in to take advantage of our online tour program. This is one of our major ways of reaching young people, and it also brings in their teachers and their parents, because we post this information on especially Twitter and Facebook. We tag their schools so that it will show up in the school accounts, and their parents get to see it. These social media posts literally have become one of the most requested mementos we get from school groups now. So that is one of the ways that we are using even Facebook and Twitter to reach young people.
Thank you. These are extremely interesting experiences and good food for thought for many jurisdictions. So we have now reached the end of our webinar today. I would like to thank our three panelists, our speakers of today, Chief Justice Bridget McCormack, Judge Stephen Dillard, and Director Craig Waters, for being with us today to share with the network's participants these interesting experiences and good judicial practices. Many thanks also to all of our audience today who joined us for this webinar of the Global Judicial Integrity Network. I think this has been our biggest audience so far. So thank you all so much for participating in this discussion. And know that the discussion about the use of social media by judges will continue in the Global Judicial Integrity Network. We hope to continue to showcase good examples, good practices, as we've done today with our panel, continue to showcase those experiences from all over the world. So stay tuned for the next webinars of the network. Don't forget to visit our website to learn more about the work on this topic and all the other topics of judicial integrity that we have been addressing with all of you, because the network is a network of judges for judges. It is here to support you in your everyday challenges. So thanks again for joining us, and see you soon. To the panelists, thank you so much. We hope to have you again in other activities of the network. Consider yourselves now participants of the network as well. So we have a little saying that once the person is on our mailing list, they're never out of the mailing list. So expect more communications from us. And thank you so much. And to everyone, we'll see you again in the next webinars of the network. Thank you.